It's nearly Friday. I'm Nino Cafaro. I'm a solicitor, and this is Talk Legal with Nino. Now, you might wonder why your solicitor asks you all sorts of intrusive questions when making your will, and it's not because they're being nosy. Well, I mean, it might be, but it's more likely because one of the most contentious things relating to wills is whether the person making the will, the testator, has the capacity to make the will in the first place. And in legal speak, we call that testamentary capacity. And of course, there's a legal test for that. And the testator has to satisfy it on two separate occasions. Firstly, when giving instructions to someone like me, a solicitor, or if they're doing it themselves and they're writing it out, don't do that. And secondly, at the time of signing it, executing the will. And if the testator lacks capacity at any of these times, the will may be invalid. The age-old test for establishing testamentary capacity is found in the common law rule in a case called Banks and Goodfellow. It's a very old case from 1870. What's the test? Well, the testator must appreciate the nature of the will and its effect, understand the extent of their property, their assets, are aware of the persons for whom they would usually be expected to provide, and are free from any delusion of the mind that would affect their dispositions, gifts to those people. And the last bit's interesting because that doesn't mean you can't make a will if you experience many losses. Many people might do when they come to make a will simply by dint of the fact that they might be older. But it's not a memory test, it's a legal test that you have to satisfy at those two critical points I mentioned before. There have been a number of challenges to Banks and Goodfellow test, one being the appeal case of Clitheroe and Bond, where the testator's son argued that the court should have applied the test in the Mental Capacity Act to establish whether the testator, his father, had capacity. And the judge followed reasoning in other cases, namely that the test in the Mental Capacity Act is to define circumstances in which living persons are able to make decisions, and that Parliament didn't intend to alter the common law test in Banks and Goodfellow, other than, of course, to provide a mechanism for allowing a statutory will to be made. That might sound a bit confusing. A statutory will is where a court allows a will to be created for someone who, ironically, lacks capacity. I'll cover that in another video. For now, though, it seems that, notwithstanding the fact that it's over 150 years old, the test in Banks and Goodfellow has stood the test of time. And one of the reasons why your solicitor is a nosy Parker. If you found that useful, hit the thumbs up. For more videos of me talking legal capacity, Nosy Parker Solicitors, just hit the subscribe button.